Good morning. You there?
Good morning, sir. Namaskar.
Namaskar. Namaskar, Sushrita. Please introduce yourself without mentioning your name.
Sir, I'm a law graduate from University Law College, and currently I'm pursuing my final years of masters at University Law College in my specialization in human rights. And this is my first attempt in
Okay. Okay. And why have you done law? Can you tell me? Why did you want to do law?
Sir, from class 7th, I had always had an inclination towards this profession because my father is an advocate and I have always been influenced by that and inspired as well. And I genuinely believe that every person, no matter whether he or she takes his or her profession as law or not, must be aware of one's rights and duties. So, therefore, I chose this profession. So.
You have chosen to practice. Why judiciary then? Your father is an advocate. You know how prestigious it is and how you can actually make a meaningful contribution to the society by being an advocate. Why are you choosing to restrain yourself in a government job?
Indeed, sir. I believe that everyone has a role to play, and the court is actually a place where both the judicial officers as well as the advocates have significant roles to play and they complement each other. Sir, for now, I wanted to attempt for judiciary because I'm interested, therefore, I want to learn new things. And if this doesn't work out, sir, despite my efforts, I would definitely try to pursue my career in advocacy as well.
No, that is what I have a problem with. Why is it that the it is a backup option? Why can't it be the priority? That's what I'm asking.
Sir, it's not a backup option. It's a choice I have made, and I have an inclination towards this. So, no matter whether in judiciary or if I fail at this attempt, or if I even fail as an advocate, I would try to confine myself in this legal sphere. If not by being in judiciary or advocacy, I'll try to go for the academics because the sphere actually attracts me a lot, sir. So any role I'm given, I'll try my best to do it, be it in judiciary or advocacy or in academics. So,
Okay. Uh, can you tell me what is a caveat?
the caveat is a warning that is lodged under section 148 capital A of CPC. So when there is a dispute going on and there are some other person who are not parties to the suit and a certain proceeding is to be carried on, and without involving such parties there cannot be proper justice. So a caveat issued by the court to let other parties who are not who by that time are not parties to the suit to come and join and look at the proceedings and to say if they have any disputes regarding that.
Okay. Okay. Can you tell me what is the where is the provision of local inspection given under CPC?
Sorry, sir, I can't recall.
Okay. What's a letter of request?
Sorry, sir, I can't recall right now.
Okay, no issues. Can you tell me where in CRPC the rights of the victim have been given?
Rights of the victim, sir?
Yes.
Sorry, sir, I can't say.
Okay. Just tell me whether the further investigation that is ordered under section 156 clause 3 by a magistrate that can be done at a post cognizance stage. That means once cognizance is taken, whether the magistrate can still order for further investigation under section 156 clause 3.
Sir, no, 156 clause 3 is at the pre-cognizant stage when the police officer refuses to take any kind of FIR. At that time, it is invoked. But if not under 156 clause 3, the magistrate can also direct for an investigation under section 190, sir, if I can remember it properly, but not under 156.3, but it can direct.
Okay, okay. What is relevant as per section 23? Sorry, 27 of Evidence Act?
So Section 27 is an exception to Section 25 and 26 of the Evidence Act. It provides for the facts leading to discovery. Sir, in this case, whatever the accused has deposed in his statements, from those statements, if a new fact or any new material is discovered, that becomes relevant under Section 27.
Okay. Why is it that the dying declaration is considered relevant, and even on the basis of it, I mean, it is viewed as a substantial evidence in some cases because the person concerned does not depose before the court. So why is it that so much value is attributed to the dying declaration?
The dying declaration, even though a hearsay evidence, is attributed relevance because of two factors. First of all, it is made under special circumstances, and the second is, sir, it is a rule of necessity in that case. Also, it is also a doctrine that is followed here that a person who dies is said not to meet his maker with a lie in his mouth. So it is presumed that he shall not depose anything that is false or something which is not true. Therefore, substantial uh, relevance is added to that statement. So.
Okay. Okay. Can you tell me whether FIR and complaint are relevant?
Yes, sir. FIR and complaint can be made relevant when it relates to the subsequent conduct of a person under Section 9 of the Evidence Act, sir.
Okay. When can a leading question not be asked?
Sir, in examination in chief.
Only in examination in chief.
Sir, also in re-examination.
Right. Can you give me an example of an acquired insanity and a natural insanity?
Yes, sir. The natural insanity is when a person is idiot, is said to be under idiocy, that is from birth. He is not under a improper soundness of his mind, and he cannot intellectually talk about things. But acquired insanity can be the stage of intoxication, where a person takes some unwholesome substances and intoxicated substances, and it is temporary in nature.
An advocate offers a bribe to a judge, and the judge refuses to accept it. What offense has the advocate committed here?
Bribery.
Okay. What is Durham rule?
So Durham's rule is a rule that is relevant for deciding whether a person is properly intoxicated or not, and on the basis of intoxication, if he has committed any kind of uh, offense. So if
Okay.
a person, while committing the offense, knows about the nature of the offense and the consequences therefore, so he cannot be said to take the defense of intoxication. But in case he does that without knowing the nature and consequences of his act, then he can plead the defense of intoxication.
What is the difference between constitution and constitutionality? Constitutionalism?
Sorry, sir, I can't.
Okay. Uh, can you tell me what's an inchoate crime?
Sir, a crime that has not been completed, or which does not have all essentials of a crime is said to be an inchoate crime, like conspiracy, abetment, uh, and sir, attempt.
What is the difference between a rash and negligent act?
The rash and negligent, although are used in a very synonymous manner, negligence is said to be the omission to perform a duty that law imposes on a person to do. But rashness is acting in a manner knowing about the danger but hoping that it shall not happen.
What is the difference between a vertical reservation and a horizontal reservation?
So, may I cite an example for this?
Yes.
Thank you, sir. The vertical reservation is the reservation that is made for the different groups of the society, like the SC, ST, and OBCs. And horizontal reservation is other reservation, which is made within the vertical reservation, like for women and physically handicapped people and for transgenders. So
Okay. Did you take personal law or contract?
it's a personal law.
Personal law. Okay. Uh, Please tell me what do you understand by fatwa?
Sir, it's a declaration which has a sanction of the elite classes of the or the we can say the influential people of the community of Muslims.
Okay. And what is isma?
Sir, ISMA is a source of Muslim law, which means consensus of opinion of the people who were the company mates of Prophet Muhammad.
Okay. Uh, you see, the check bounce cases or any cases involving the negotiable instruments could be very well filed filed as a civil suit. Why is it that a special enactment is there to decide the cases?
Sir, it has been made as a criminal offense for the first reason that sir, if not made, then it would lead to various consequences in which many people will do that and escape by doing so. And since civil cases take a long time for disposal, for the expeditious disposal of the cases, this has been declared as criminal offenses. And secondly, sir, if it would have not made a criminal offense, then, sir, everybody would have done the same thing and have escaped the liability.
Okay. Can you tell me the can you tell me your views on liquor ban? Because the Gandhian principle, according to DPSP, says that there should be a complete ban on liquor. And also, I think the states which have banned the alcohol have noticed a considerable decrease in the crimes. Okay, because the consumption of alcohol is directly proportional to the crimes. So why is it that all the states are not banning? I mean, what is your view on it?
May I give my personal view on this?
Yes, yes. I want
Thank
your
you,
view
sir.
on this.
Thank you, sir. Sir, I genuinely adhere to the Gandhian principles, and I believe whatever you stated that the rate of crimes are directly proportional to the consumption of alcohols. So, sir, I believe that although we draw a big amount of revenue or taxes from all this, or economy is generated by selling and doing the trade of alcohol, but it should not be done at the cost of public interest, sir. Because when a person consumes that, even though he contributes to the economy of the country, but he is inviting hazards not only for his own health, but also family and society at large. Therefore, I believe that the ban should be there and it should be at a larger rate and it should be it should be penalized as well, sir.
Okay. Okay. Can you tell me what is a preemption? What is a preemption? What do you understand by preemption?
Preemption is a compulsory right to purchase an adjoining land or any adjoining property. of the person who owns another land.
To purchase as in I did not get it.
Sir, if a person who owns a land has an adjoining land that is owned by some other person, and such other person has sold it to any other person, so this person, the first person who has the right of preemption, has the right to move into the shoes of the buyer. So he can buy the land from the buyer who has actually bought it from the person to whom the land belongs.
Okay. Uh, okay. Yes. Can you tell me what can we do so that the bridge between the uh, courts and people at large can be increased further, because people still fear approaching courts because they think that it will take a lot of time. They go for ADR methods and all. I think most of the companies now they are opting for arbitration and conciliation instead of coming to the court. So, do you think that court has something else to offer for which we can probably ask people to come to the court when they are facing any problems?
Sir, I believe that these alternative methods of ADR or arbitration and conciliation are very effective at their own places. It reduces the burden of the courts and it also aids in expeditious disposal of the cases. So, sir, I believe this parallel system must exist. So, the courts are doing their duties properly by dispensing proper justice to the needy people. But this alternate remedies that are available are aiding the court by doing that. And even if a person fails to get justice in those methods, the door is always open of the Court of Justice to entertain such issues and dispose it according to the law, sir.
Okay. Suppose you are sitting as a judicial magistrate and you have a child, and then there is a threat call to you which says that if you do not pass judgment in my favor, I'll kill your child. What will you do in such a case?
There is a child mine, and
Yes,
is he
yes,
or she with me?
yes.
Sir, it will be sir, in that case, if the child is with me, I shall not pass the judgment in favor of such person. Rather, I will pass the judgment, what is the need of the law or what is the need of the, according to the need of the case, sir. And thereafter, I can file an FIR or any complaint for getting such threat calls, sir.
Okay. Okay. Thank you, Sushrita. That will be it. Now let's proceed to your feedback. Just a
Yes,
second.
sir.
Just wait a minute. We'll proceed to your feedback.
Sure, sir.
Yes. Sushrita, I was asking, I had asked, yes, I think some questions I asked you, you could answer them very well, but some questions you could not recollect because of probably lack of revision. That I can see, because I see that you are a bright student and you have a fair chance of clearing the exam this time. But yes, revision is the key here. The more you revise, the more the retention will be there, and then you can reproduce better even when any question is asked randomly. Okay, like I asked you, what's a letter of request? That's a summons when it is sent to a dignitary. So instead of sending a summons, you send a letter of request.
Yes, sir.
Local inspection, yes, Order 26, Rule 9. If you seek under commission, there is a rule of local inspection. Okay. Then I ask rights of victim, that is given out 357, 357A, B, C, and 350, 372. All
Sir,
these
I
are
was a
right.
bit confused about this because it's written compensation to victims, so I was a bit
But
confused.
that's compensation to the victim is a right of the
Yes,
victim
sir.
that he'll get the
Yes, sir.
compensation.
Yes,
Okay.
sir. Yes, sir.
Whether after 156.3, after cognizance 156.3 can be taken, yes, can be taken at post cognizance stage, but before the commencement of trial. That is sent in the Binnu Bhai Haribhai case. Binnu Bhai Haribhai case, it says so. Okay. Then uh, just Then I asked you about constitution and constitutionalism, whereas constitution is a text, constitutionalism is the spirit that it embodies. You read upon it more.
Sure,
Yeah.
sir.
Then I asked you about the horizontal, vertical. You could say that properly. Dying declaration, you could also say. Section 27, you could say. Rash and negligent act, you could say. Durham rule, yes, you could say. Fatwa is a fatwa is what? Fatwa mm, is a opinion of the jurist. Opinion of the jurist, not of any other class of people, but an opinion of the jurist. Difference
Okay.
between horizontal, vertical, you could say. So more or less, you could say yes. I am impressed with your introductory answers, the way you manage the interview. I mean, you are polite, you are humble, and yet you are not underconfident. You appear to be confident to the right extent. I mean, I've seen people who appear overconfident, but I don't think the mannerism or etiquettes need address at all. That you are on point. Okay, just just make sure that you revise everything once again properly, not once, maybe multiple times, because that's what you need. Okay, and then I see that you're clearing it this time. If you just do a good revision of about 4 or 5 times, you're going to clear it this time. Okay, all the best, Sushita. We'll have our second mock, which will be a two judge panel mock. That will be on probably 11th or 12th. So get ready, and immediately, when is your final interview?
Sir, it's on 20th.
20th. So on 18th, probably we'll have the third mock, that which will be a three judge panel interview.
All
Okay.
right.
So be prepared. I'll just say revise as many times as you can until you finally give the interview. Okay.
Sure. Thank
Thank
you.
you. Thank you, Sushrita. You may
Namaste.
enjoy now. Namaskar.